This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
Good morning and welcome to ADR Services, Inc. Episode 1 of this series on trust estates and probate matters. This presentation will focus on conservatorships and an introduction to conservatorships. We do have 2 other events in the series related to 850 petitions and fiduciaries and trustees, which will be in August and November. Feel free to cruise over to our website if you would like to register for those 2 events in the series, featuring some of our other trust and estate neutrals and some familiar faces from this webinar as well. Some housekeeping here at the top of the presentation. This presentation does provide an hour of general MCLE credit. You will receive your certificates via email by the end of the day today after the presentation. So keep a lookout for those. And without further ado, I'd like to introduce our wonderful speakers this morning. First up, we have Bette Epstein with ADR Services, Inc., neutral available for mediation based here in Northern California. We have Judge Barbara Johnson, recently retired from the Los Angeles Superior Court, based out in LA, and Bruce Ross, based out of Orange County, right, Bruce?
No.
Oh, excuse me, Los Angeles area, right?
Orange County's not far.
Okay, sorry about that, Bruce, but all 3 of them are wonderfully experienced trust and estate neutrals, and I look forward to hearing their insights on conservatorships today. So to give a brief overview of our agenda, first we're going to be going over some of the basics related to conservatorships, and then moving on to some alternatives to conservatorships, and then finally the 2021 revisions to the law. So without any further ado, I would love to turn it over to our speakers, beginning with Bette Epstein.
Okay, good afternoon. So turning to the basics, the next slide. There are actually 3 types of conservatorships. There's the probate conservatorship, which is the one that we see most of. And that's what we're going to be focusing on today. And I'm going to talk a little bit about that. There's also limited conservatorships who, for people who are developmentally disabled, adults who are developmentally disabled, and who are clients of the regional center. And there are special provisions for those individuals. And then there's conservatorships under the Lanterman-Petra-Short Act, which is actually through the Welfare and Institution Code. And those are for people who generally have psychiatric conditions and are determined to be gravely disabled. So that's a whole different procedure for those conservatorships. So what we're going to focus on today, and this really is an overview because we could easily spend a full day talking about all of the aspects of conservatorships. So this is really an introduction to help you become acquainted with the probate code sections and kind of generally how they function. So starting with probate code section 1800, part of it, one of the big issues that we deal with is the preference for appointment of a conservator. And so probate code section 1810 talks about family members, spouses, children, parents, who has preference, because oftentimes in a contested conservatorship, which is what we as mediators see most of, one of the big issues is who should be appointed conservator. It's also critical that a citation be served on the proposed conservatee. And even though they may be really severely incapacitated and don't understand the contents of the citation, it's important. That's an important aspect of their constitutional rights, that they're given that notice. The other person who's involved in a probate conservatorship is the court investigator. And that person is someone who is employed by the court and is there to assist the court in both meeting with the proposed conservatee, talking to all of the people who were involved, the petitioner, any people who were in opposition to the conservatorship. And that person carries a lot of weight with the court. Sometimes they take strong positions as to whether a conservatorship is appropriate. Other times they're more neutral. But certainly working closely with the court investigator to assist them in getting access to the people that they need to talk to is very important. And your analysis about someone's need for a conservatorship and whether that's an appropriate course of action has to begin with the issue of legal mental capacity. And looking at probate code sections 810, 813, that's kind of your Bible as to what you should be considering as to whether someone would meet the qualifications to be conserved. Another important aspect to keep in mind is notice, which goes to family members of second degree. So even those family members who may have no relationship with the proposed conservatee, they're entitled to notice. And most all of the information that is presented to the court in a petition for conservatorship is through judicial council forms. So those, I believe, are referenced in the materials that Bruce is going to be talking about, but those forms are critical to the process. So you should be certainly become very familiar with those forms because they really are the roadmap for getting a petition on file. So let's go to the next slide. One of the big questions, the other way, is who could petition for conservatorship? And basically just about anybody, because the probate code under section 1820 says any interested person. So it can be certainly family members, neighbors, private professional fiduciaries, and even the proposed conservatee. I had a case actually in which my client was in the middle of a big tug of war between her current husband and her ex-husband, and they were both putting a huge amount of pressure on her. And we decided that the best way of handling it was for her to petition for the appointment of a professional fiduciary as conservator.
If I might, Betty, I also like to mention the Mickey Rooney case, which some of you are no doubt familiar with. In that case where Mickey Rooney was clearly being subjected to significant financial elder abuse, with his permission and indeed at his request, we obtained the appointment of an independent fiduciary in the face of massive litigation, which went a long way toward protecting his interests. So that's something to think about, even because it is voluntary. You have a full discussion, of course, with the client. But if they look at all the options and they have the capacity, because it's not a question of whether a proposed conservatee can be conserved without a finding of legal incapacity, then it is something definitely to keep in mind.
Right, and that particularly comes where there's just such what would be described as undue influence or such strong influence that puts the proposed conservatee in a very difficult position. The other thing,
if I may, Betty, you have to remember also, we have to remember also that an interested person is, as you said, can be anybody. They can be a debtor or a creditor, rather. They can be, and even though a family member or a spouse can be a petitioner, that doesn't necessarily mean that a spouse is the appropriate person to be the conservator, because especially let's say that they're in a divorce situation, we wouldn't want, and they have to divide the property. We wouldn't necessarily want the spouse involved in that as a conservator, because property issues may be a estate if it's a conservatorship of the estate.
Right.
And so the court is given broad discretion, let's say that, in determining what's the best interest of the conservatee at that particular point. And it may be in the end that the spouse, even in a dissolution process, may be the correct person, but we just can't automatically say, okay, the spouse or a family member is going to be the person that's appointed, who can petition for appointment.
Well, and one of the things that we often see is competing petitions, where more than one family member has petitioned. My approach when I was representing individuals, and there was another family member that was going to create a problem, is to seek the appointment of a professional fiduciary, because that makes it an easy call for the court. But I know, Judge Johnson, you have a different view about whether it's necessarily the right course of action to appoint a professional. So why don't you share your thoughts about that?
Well, my point is that we shouldn't automatically assume that a professional fiduciary is the right person when there are family members, even if competing family members want to be it. And so you have to decide, one, whether the state can afford it, and two, whether the family member can sort out their own disagreements, so to speak, and whether that family member who is competing just wants to do it just because, or because they're actually qualified. We have to make sure that the person is qualified to be the conservator of the person and of the estate. And so I don't automatically jump to professional fiduciaries, not that they, and the family member may need to be bonded, which is another requirement. We don't want them taking over, even if it's their close family member estate and they have no knowledge of accounting, which is very important in conservatorships of the estate, or they have some grudge against the person that they're seeking to be appointed conservator of the person for. So, and plus, if they're appointed conservator of the person, there are other things that may come involved. If the conservatee disintegrates in terms of physical abilities to do things, they may have to make decisions in the future about, their life, basically, which is another subject. I know this is a general, but I'm just saying that there are many reasons why or why not a family member, as opposed to a professional fiduciary, should be appointed. My point is, I don't automatically assume because a person is in the profession that they are automatically right for a particular appointment.
I think it's probably also worth pointing out that if you are having both a conservator of the person and a conservator of the estate, that does not necessarily have to be the same individual or entity. And it may be very appropriate to have a family member as conservator of the person to provide for the personal and physical and health needs of the conservatee, and yet have an independent fiduciary. If you look at these cases, most contested conservatorships do not involve the fundamental issue of whether or not the person needs a conservator.
Right.
In all cases, it's fairly obvious they need help with their personal and or financial affairs. The battles come in over who should be the conservator, or should there be two conservators? And I think as counsel for parties, family members in particular, who are involved in these unfortunate cases, we need to be creative and to think about several different ways that the problem might be solved, and what's the most appropriate suggestion or petition to bring to the attention of the judicial officer.
Right. So we're going to talk about alternatives in just a minute, but one other thing I wanted to go through, and if you'll put on the next slide, because I think this is important, because people get kind of caught with what a conservator doesn't have control over. So oftentimes what is made available to the conservatee is an allowance, where the court will order that the conservator give the conservatee access to a certain amount of money every month, for which there is no accounting. Also, if the conservatee is working, and they have wages or a salary, that is not within the jurisdiction of the conservatorship proceeding. So that money is available for them to do as they please. They have a right to make a will. They don't lose that right as a result of a conservatorship. And they have a right to enter into a transaction to the extent that it's to provide for necessities. So whether that's for healthcare or food service or some other necessity of life, they have the right to enter into that contract, although typically not other contracts. One other really important aspect of a conservatorship in terms of what it doesn't do is it doesn't address assets held in trust. And oftentimes a proposed conservatee has the majority of their assets in a trust. And so that may require a separate proceeding to address whether there needs to be an accounting or there needs to be a change in trusteeship. One other important thing is if a proposed conservatee is the trustee of their trust and they are conserved, then they're then disqualified from serving as trustee. So it's oftentimes the case we see kind of parallel proceedings, one dealing with the conservatorship and the other dealing with the trust. So just it's important to be aware that the lines don't typically cross. Although I did have a case in which in a conservatorship, when there was concern about the beneficiary of a trust not getting access and not being able to monitor the actions of the trustee, that once the court heard the facts, the court suspended the trustee in a conservatorship proceeding. So that was a result that we were pleased with, a little bit surprised about. So you never know what the court may do, but typically it requires a separate proceeding. So let's talk about the alternatives to a conservatorship, because one of the things that the court must do is consider the least restrictive alternatives. A conservatorship should be a last result. So when there's issues of supervising care, one of the things we often talk about is the appointment of a geriatric care manager. And that's someone who can typically supervise the home. This would typically be when a proposed conservatee or conservatee is living in their own home as opposed to a facility. They may arrange for care, for professional caregivers to come in, but rather than a conservator doing that, a less restrictive alternative would be use of a geriatric care manager. And then there's no expense result in terms of court proceedings and those kinds of things. If the proposed conservatee has the capacity to appoint a power of attorney for financial management, that's an alternative. And I know there's a recent case, Bruce, you're going to tell us about the conservatorship of Ferrant that deals with powers of attorney.
Yes, before I mentioned conservatorship of Ferrant, most of you who are on the call, especially if you're estate planning attorneys, know that we have two very different kinds of powers of attorney, both the ones that come into existence immediately and lapse in the event of incapacity of the client or the appointing or the principal, and of course, durable powers of attorney, which by definition continue on even after a principal is incapacitated. And with respect to durable powers of attorney, we can have both durable powers that go into force immediately, or as is often, perhaps more commonly in the case, obviously, of a capacitated client, a power of attorney, a durable power of attorney that is a springing power that springs into existence upon incapacity. Both these, well, the durable power is a very useful tool and can avoid the necessity for conservatorship entirely. At the same time, it's important to, just as the court is ultimately going to be concerned with the qualifications and lack of conflicts of interest of a proposed conservator, in planning a durable power of attorney, you want to make sure that the person who is being appointed is qualified to act and doesn't have any potential conflicts of interest. It's also, this is a recent case, and I think, frankly, this was the law in any event. In the event of a problem with, and we have a whole separate set of statutes, which we won't go into today, dealing with powers of attorney, but the holder, the attorney in fact, can be subjected to the jurisdiction of the court. And in cases involving potential breaches of fiduciary duty or just misuse of the power of attorney, the court is ultimately going to be the arbiter of those issues. The case I want to mention is a recent case, just came down within the last year. It's Conservatorship of Farrant, Farrant, 67 Calap 5th, 370. And this is a reminder that an attorney, in fact, may indeed be required to render an accounting for assets that have come into her possession, even if the principal has died. This case involves someone who had passed away, and yet the court compelled the attorney, in fact, to account to the executor of the estate for alleged misconduct as the attorney in fact.
So the sometimes people, the proposed conservatee has a healthcare power, advanced healthcare directive, or power of attorney for financial management, and the petitioner seeks to have those suspended because they don't believe that whoever the agent is that has been appointed under those documents is the appropriate person. So that's one of the discussions that we have as well as the opportunity to create ones if they don't already exist. One of the overall themes that I see in conservatorship proceedings that are contested is a lack of transparency, where family members don't know what the assets are. They don't know how they're being utilized, if they're being utilized appropriately. And when they try and get information, they can't. And so filing a petition for conservatorship is a way to kind of open the door to find out what's really going on, both with the finances of the person who would be the subject of the conservatorship, as well as their health care. So one of the things we see is family members who are in disagreement with typically an elder as to whether or not they're getting proper medical care. And I know Judge Johnson has been faced with the fact that someone chose not to get treatment for a serious illness.
Right.
And the family member wanted the court to order that person get treatment. So Judge Johnson, what was your perspective on that?
Well, I went back to the code and to determine whether or not the family member under the code, there are certain requirements to appoint for a conservator of the person. If the proposed conservatee has a place to live, can provide for herself for a place to live, can feed herself, and not roam the streets or anything like that. In this particular case, she happened to have an illness, cancer, I'll just say, for instance, and she wanted to be treatment a certain way, and the family members wanted her to get treatment, and she didn't want to get treatment. So they wanted me to appoint a conservator of the person. Well, she didn't fit that. She was knowledgeable and was not, as I said, she was able to say, no, I don't want to get treatment for this. And so I didn't appoint the family member for a person knowing that, they would probably force her to get treatment. But I did appoint for the estate, a family member for the estate, because she had lost a great sum of money before the family members became aware of it. And I thought that was necessary. But so we do have to, we just can't, because of their constitutional right, we just can't willy-nilly say, okay, well, she needs help, she's not getting help, and therefore let's appoint a conservator of the person. And so we do have to be careful in how we approach these conservatorship appointments, recognizing they do have constitutional rights in all the instances when we're doing this.
This might be a good time for me to mention the materials that are far too extensive for us to cover today, but that are included with your participation in this seminar. With the permission of the Rudder Group, we have transcribed, or we have included the text of a portion of Chapter 1 of my and Gerald Cohen's practice guide for probate, which deals very extensively with conservatorships in all of its aspects. And there is a discussion, which I think is well, I know it's accurate, and I think it's relatively comprehensive about this very important constitutional right to self-determination. We cannot ignore throughout the whole idea of conservatorships is it's protective, but at the same time, we can't be talking about, removing rights that each of us has under the Constitution. The distinction, and this comes into great play in LPS conservatorships, where the standard of proof is higher. It's criminal standard of proof. And there's a right to a jury trial. We're not going to go into this because those cases are always handled by county counsel, but it's important to keep those concepts in mind. I also have a little disclaimer. I was just diagnosed with COVID this morning, but despite what you may have heard to the contrary, there is no medical evidence that it can be transmitted by Zoom. But I do want to apologize for this. And if I go on mute, it's because I'm coughing. So otherwise, I'm delighted to be here.
And we're going to talk about this subject later on when we talk about preferences with the new laws, Bruce, that you're going to be talking about later on in the afternoon. How that might affect, the appointment of the least restrictive alternatives,
right,
and such.
So one other thing that we talk about in trying to address the concerns of the petitioner who is seeking oftentimes information and a method of handling finances is, for instance, to use a bookkeeper who will basically take care of paying bills and providing information. And so one of the themes that I see in contested conservatorships definitely is somebody needing more information than what they're currently getting. And the resistance can come from the proposed conservatee, can come from a spouse, can come from one of several kids who doesn't believe that their other siblings need or entitled to information. And so a conservatorship proceeding, even if the conservatorship doesn't ultimately become established, is a way to get information, and I see it being used for those purposes. So they're interesting proceedings. One of the things that I particularly enjoy about mediating conservatorship cases is they really need an immediate solution. If family members are arguing about a trust or estate, it can go on for years. But in my view, if you've got a pending conservatorship matter, it needs to be addressed and a resolution happen quickly.
And the appointment of a temporary conservator doesn't fix that.
No.
People use the temporary conservatorship and it drags and drags and drags. And you might as well, it never gets to the court being able to make a decision, except temporarily every month, it has to be extended and such. So we need to really try to don't use the temporary so much just to try to find out the information that you want to get. And then, okay, I'm done with it. We need to get to a permanent conservatorship appointed as soon as possible.
I totally agree with that, having looked at that from a trial lawyer's perspective and seen these temporaries drag on and all the relief you were hoping to get and protection for the conservatee. If it doesn't disappear, it's definitely damaged in the process.
Right.
Things are a little better, perhaps, with some greater attention to notice, but the temporary conservatorship, in my judgment, too often is being used as a tool by someone who wants to gain immediate control over the over the proposed conservatee. And unfortunately, our courts are so overwhelmed already with cases aggravated by the COVID crisis that a temporary conservatorship could end up running much longer than should ever occur. So
My opinion is make a decision. That's what I try to do, is make a decision, not to try to, even with the time frame, that's the best policy, I think.
And unfortunately, Judge Johnson is no longer on the bench. But,
Right.
So that's what I tell them in mediation. Make a decision. Let's make a decision. Let's not, trail this so much longer in the future.
And that's not a criticism directed at any currently sitting members of the
Absolutely not.
So we have another really important topic. So let's go to the next slide, because there have been some significant changes in the law. And Bruce is going to educate us on these changes. So
Yes. Thank you very much, Betty. All of these changes were affected with major conservatorship litigation enacted just last year. Your written materials, which for the most part consist of the 2021 version of the Rudder Group Practice Guide on Conservatorships. In this case, included in your materials is a supplement, which hasn't yet been revised and edited by the Rudder Group, but which I hope is more or less correct. It will show up ultimately in the 2022 version of our book, which is currently in the editorial process. So with that caveat, let's talk about these. And again, because this is a basic course, we're not going to go into enormous detail here, but these are things you need to know about. It's fair to say that one of the predominant factors in a close look at the law of conservatorship is the controversy that arose and it has been litigated in connection with the Britney Spears conservatorship. We're not going to go into that case, but that is, in fact, what some of these changes are caused by, or at least so much attention was given to that conservatorship and many of the issues there that we now have additional provisions with respect to conservatorship law and regulation. Taking these one by one, and this is a mistake, and it's my mistake. It's not ADR Services mistake. This is not Probate Code Section 6563. That is Business and Professions Code 6563, which regulates professional fiduciaries, and among other things, this will require, effective January 1, professional fiduciaries with an internet website to post a schedule, a range of the licensee's fees, because again, all professional fiduciaries must be licensed by the state. So this is important, and their fees now will have to be set out for those with an internet website. And similarly, effective January 1, 2023, professional fiduciaries without a website must provide any prospective client with a schedule or range of fees, including but not limited to hourly fees for services before the execution of the contract. Now, this is something telling us as lawyers what we should already know anyway, which is you've got to have a discussion of the costs, and not just if you're talking about a professional fiduciary, but if you're talking about any other fiduciary. And of course, banks and trust companies are not regulated as professional fiduciaries. They're regulated under other provisions of our law, but they too, obviously, everyone should have full transparency here with respect to what the projected costs and fees of a conservatorship will be. There's further provisions where the Bureau, Professional Fiduciaries Bureau, which is the state agency that regulates fiduciaries, to impose sanctions on a professional fiduciary for breach of fiduciary duty where there is a finding of serious financial or physical harm or mental suffering, and or if the professional fiduciary has engaged in certain defined acts of abuse. Hopefully we won't see any of those cases, but we do have additional legislation regarding sanctions in that case. Also, the Bureau is given the specific authority to investigate such cases either on its own or upon receipt of a complaint from any person. I see this as somewhat analogous to the provisions that regulate us as lawyers under the State Bar Act. In other words, anybody can file a complaint, and there will be an initial inquiry and then further investigation if there are problems uncovered. The second point here, excuse me. The second point here requires the Judicial Council to study over the next couple of years the effectiveness of the courts in handling and regulating conservatorships. So this isn't going to, this is not something that we need to be directly concerned about, but it is important to know that the Judicial Council on or before January 1st of 24 must provide a detailed report to the legislature with findings of a study of at least 3 courts measuring court effectiveness in conservatorship cases, including the effectiveness of protecting the rights and best interests of the conservatee. And that language, rights and best interests, is in the statute itself. This is a correct citation. It's Probate Code Section 1458 that has been added. There's a series of requirements that and statistics that the Judicial Council is required to collect. And we've been told, we don't know which courts are going to be picked, but we have been told that there will be at least 3 courts. There will be a small court, a medium-sized court, and a large court. And I'm assuming that does not refer to the measurements of the courtrooms themselves, but rather the size of the population that the particular court in question is effectively overseeing. Let's talk for a few minutes about 1471, and I know Judge Johnson will have some comments on this. This is a significant change. Under the law until now, when a lawyer was appointed for a proposed conservatee, typically from a panel of volunteers, not exclusively, but typically, they would be charged with representing the interests of the conservatee. That language has now been changed, and the attorney is directed specifically by the statute to provide zealous representation of the wishes of the conservatee. So bear in mind that the conservatee may be seriously mentally disabled. Nevertheless, if their wish is to oppose the conservatorship, that is indeed what the attorney who is appointed to represent that conservatee must do. There's been a debate about this issue of the scope of the representation of the duties of the lawyer representing somebody who is allegedly in need of a conservatorship. It has gone on for decades, frankly, and I think it's going to continue to go on. And there are arguments on both sides of this issue, because those who look at this as a protective proceeding would argue that the best interests of the conservatee should be discussed and not necessarily the wishes of the conservatee. Nevertheless, the legislature has made a conscious decision now to insist that the attorney provide zealous representation. And also important in this area, the court must appoint private counsel or the public defender, and that's probably likely when there are no assets to pay for private counsel, in any case where a conservatee or proposed conservatee has not retained or does not plan to retain legal counsel. In addition, if the proposed conservatee expresses a preference for a particular attorney to represent them, the court must allow, shall is the mandatory word here, but shall allow representation by the preferred attorney, even if the attorney is not on the court's list of court-appointed attorneys. And the attorney must then provide zealous representation. Now, again, this is likely to be somewhat controversial. I worry about this because I've had cases in the past where the preference expressed for the attorney, in my judgment, was the result of undue influence exercised on the person by the attorney. I'm certainly hopeful that with this change, the courts will nevertheless inquire into this problem. And with that, with my comment, I'd love to hear from Judge Johnson and Bette.
And I have one, there is a question about how a guardian ad litem coordinates their efforts with court-appointed counsel.
Well, I think that in my experience, we hired 2 attorneys are appointed, one for zealous and one for the best interests of the conservatee. And that was even before this law passed. So, and I've had that happen before. And the person who's representing the conservatee with zealously will say, even though they may not agree, they're there to do their job just like a public defender. We don't have public defenders in LA courts yet. I'm sure we will. Some other counties do automatically appoint public defenders to represent the conservatee. But I think that for the zealous representation, the attorney will address themselves to the court and says, my client, to the judge, knowing what that means, my client would like this, this, and this to happen. And my client thinks this, this, and this is going on. And I would like to, go forward in his zealous representation. Now, we don't know since this is the law, whether that means there are going to be more jury trials as a result. I tend to think not, because I think that even though one attorney is representing the best interests and one is representing his client zealously, I'm just using those words because those are part of the statute, will have conversations. I don't think they would be against the law to have conversations because they have the same client. And they will together work out what is not only suitable to the client, but suitable to the best interests of the client.
And this is interesting. I just pulled up a question that came just a few minutes before we introduced this topic, and I think it's well worth discussing now.
In the chat.
The chat, yes. This is from a quote unquote anonymous attendee. It's a good question. You have been talking about the conservatee's constitutional rights, but I see from the materials that a prospective conservatee or actual conservatee, and I'm guessing someone who is a conservatee, correct, has no right to counsel, and that it's in the discretion of the judge. How can this be? This seems to have been at the heart of the Britney Spears matter. Please comment. And my comment is yes, and that's why the legislation has been modified. So I don't want to sound defensive, but the materials are right, but they were right when they were written, because that's the 2021 version. But I encourage you to look at the last 4 pages, which will be in the 22. Maybe it's 3 pages. I don't remember now, but it'll be in the 2022 revisions. And indeed, yes. Without going into detail, there was a grave concern in connection with the Britney Spears conservatorship that the attorney who was appointed off the probate volunteer panel may not have as aggressively represented her interests as one might have liked. And that I'm not going to comment further. It's been discussed at great length. Well,
this issue is going to come up also, Bruce, with the preference, because there's also a section about the preference of the conservatee and how does one determine whether that preference request is unduly influenced, whether the preference that the conservatee has chose, the preferred attorney that the conservatee shows is even capable, has ever been in a probate court before. Are they able to do it? And right. So, and then it's up to court to say, well, okay, that's your preference, and I'm going to take that into consideration. And there's some levels you go down or up to see whether or not that preference should in fact be granted.
Right.
So, yeah, and I think ultimately here we do need to rely and should rely on the court's discretion and ability to see through these issues. I mean, that's why we have courts, to decide disputes that the parties, for one reason or another, can't agree on. So,
Bruce, maybe we need to move on to the duty of the court investigator, because as I mentioned, that person is a really important component of any conservatorship proceeding in terms of what their perspective is and what information they're able to obtain.
Yes, thank you, Betty. Here again, we have new legislation or amendments to legislation and new legislation. The new legislation is the new probate code section 1851.6. The amended section is 1826A through H. 1826. Oh, yes, I see it down there now. There are several matters that are dealt with here with respect to the court investigator. And this is subject to an appropriation of funds by the legislature. And as we speak, I'm not aware that those funds have been appropriated. So it's probably not going to happen right away. But there has been concern, and I'd love to hear from Judge Johnson about this too, but there has been concern expressed more than once about the court investigative process and how superficial sometimes it may appear to be. This legislation, without going into great detail, would substantially increase the role and responsibility of the public investigators. It's clear, at least from my reading of the statute, that it's going to require training for the public investigators because there are some very significant changes. One of the most significant is the probate investigators are expected to gain access, subject to confidentiality, to the medical records of the proposed conservatee. And so those are issues that will end up, there'll be obviously much further discussion about these issues and pending actual appropriation of the funds for that purpose. But Judge Johnson, your thoughts on investigators?
Well, even now, again, before the law, we got investigative reports and yearly investigative report, initial investigative reports and yearly investigative reports. And so those reports, most of the time, just say they go to the home. This is before COVID. Go to the home, interview, see the surroundings that the conservatee is living in, interview the conservator if they're there, and say, they look healthy. They go into the doctor or they've been in school or whatever it is, and report that to the court. Now, on occasion, the reports are incomplete for what we need them to be. And I would assume that it's because they've been overburdened with so many places to go, people to see. And so the reports are rote reports. You can probably write them. If I'm reviewing them, and I used to get maybe 20 to 25 a day to review them to see if they match. And usually what I'm looking for is if there's an estate, it didn't include the estate, or if it's just the person, did they speak to the doctor or whatever. And so I'm curious to see if they're going to require more of them, how they're going to fund more of them, because it's going to take more people. It's just like social workers. Sometimes there's this overburden, and it's going to take more of them to review conservatorships in this country where the population itself is getting older. And so therefore, many more conservatorships are at hand. But the judge needs complete reports so that we can determine whether or not the conservatorship should continue. And generally, after I'm reviewing it, I'm seeing whether or not there's any objection. Has there been any change in the circumstances? Has the conservator themselves aged such that they can no longer care for the conservatee? And so then I have to set a hearing to determine that, to see what's going on. But it's important that we have these investigative report, and that then the reports themselves be complete, so that we can determine whether or not the conservatee, first, if the conservatorship should continue. Maybe the person has, gone to school, aged out. Well, that's probably guardianship, but has gone to school and no longer are self-supporting, whether or not they even need a conservatorship still. Whether or not they even need a conservatorship of the person or of the estate, or do they really need a conservator of the estate since they get so much limited funds anyway? A regular person can handle that without a need for an accounting, because we know that they get Social Security or whatever it is that they're being supported by, or IHSS or whatever. So we really have to be concerned. We shouldn't just do things just to have them in process, just to keep doing them when there may not be a need for it.
Conservatorships are based on a change in circumstances that then the person recovers if they've been seriously ill and they can't manage things for an extended period of time because they're undergoing treatment or they just need time to recover from the illness. And conservatorship may have been appropriate at one time, and then hopefully it no longer is.
Right.
And
So
if I may, that
perspective.
the 2021 legislation, as is implied here or expressed in number 5, will require the courts to consider at least every year or year after the conservatorship is established, whether or not to terminate a conservatorship or to remove a conservatorship. So it's not just reliant now on private action by somebody who may be unhappy. And I want to interject here. It's a bit beyond the scope of the program, but for those of you who are estate planning attorneys, I think additional attention needs to be given in advance to the proposed ways of avoiding a conservatorship for your client who, although now incapacitated, may become incapacitated. So extra thought should be given, in my judgment, to durable powers of attorney, but not just the notion of a durable power, but who is the right person to act as attorney in fact. And if you're picking a family member, which may be totally appropriate, perhaps a side letter to the other family members as to why you're picking out one family member as opposed to the others will go a long way toward avoiding the unfortunate litigation that does occur when the individual clearly needs court protection, absent some other alternative, less restrictive alternative to conservatorship. Also, don't forget the importance of a nomination of a conservator. And again, if you're nominating one of several family members or whoever you're nominating, if you have a side letter that could even be directed to the other individuals. Look, I'm not picking my daughter Elizabeth because I love her more than my son Stephen or John. I'm picking her because she lives near me. She has been caring for me. Whatever it is, the more explanation that one can give in advance. And one other point here has to do with the ethical duties of an attorney who's representing someone who appears to need a conservatorship. A lot of discussion about this, and in particular, Model Rule of Professional Conduct 1.14, that in the ABA's version permits an approach by an attorney for someone who now needs assistance to contact other individuals. That Model Rule 1.14 was not adopted by our Supreme Court when California finally adopted, albeit in modified form, the ABA Model Rules of Professional Conduct. We were the last state to do so. There is, however, a recent opinion. I don't have the site in front of me because I didn't think to mention it until just now. But it's a recent opinion from our Committee on Professional Responsibility, which notes that it would be unethical absent a consent by the proposed conservatee for a lawyer to break what California, unlike some other states, regards as absolutely inviolate confidentiality imposed by Rule 1.6 to seek outside help absent the client's consent. But it does, and I think this is very helpful for lawyers here in California, it does say that a lawyer may talk to her client in advance and discuss, if you are incapacitated or you may be incapacitated, do I have your approval to go to a family member or some other respected individual, or maybe even the court? Because if the approval is given in advance by the client who's been fully informed of all the alternatives, they may well say, yes, I don't want my family arguing about this. after the fact. So again, that's something important to bear in mind, I think, from a planning perspective.
So one more thing on your list, Bruce, is the additional safeguards regarding conservatorship hearings.
Yes.
So we have just a few more minutes to.
Yes, I noticed that. We have 4 minutes. I'm not going to take 4 minutes. Again, we'll need to look at these statutes with some care, and no doubt we'll get further input and discussion of these. But among other things here, we're going to have a greater concern for why the conservatee may not be present at the hearing. Why the conservatee may not be present at the hearing. So you can't just, say, I mean, you're supposed to have a doctor's consent. I think it might take a little more now under this provision. We want to know if the proposed conservatee is not there specifically. Why isn't the proposed conservatee there? There'll be further safeguards with respect to modification or termination of the conservatorship. I've mentioned those, and I want to mention one anecdote, just for fun, frankly. But it was years ago. I'm reminded of it by this my discussion of this statute. This was years ago, and many of you, I hope, will remember. I hope I'm not too old or older than everybody, but many of you will remember Commissioner Ann Stodden, who was a real bulwark of the probate court here in Los Angeles for so many years. And there was a case many years ago. I was not there, by the way, but there was a case where there were all kinds of folks at the hearing, and several lawyers, and they were all arguing. It was a decedent's estate, and they were all arguing. And there was an much older woman standing at the council table, somewhat befuddled. And the commissioner looked over at her and said, "And who might you be?" And she hesitated a moment and then said, "I think I'm the decedent." Anyway, so take every case you have with a modest amount of humility and sense of humor, and everybody's going to be fine. Subject, of course, to the court's decision.
There was one question, and I don't know the answer to it. The first question had to do with Governor Newsom's proposed care court to address issues with unsheltered people. Do Judge Johnson or Bruce, do you know anything about that and how that may come into play, and where? Are we talking about probate court, mental health court? I don't know. I don't have any information about that.
All I've seen so far is what's in the what's been in the newspapers. I haven't looked into it. It's an interesting question. Again, remember, constitutional rights are involved here, and those extend to all of our folks who are homeless, and the LPS provisions are very appropriately aimed at safeguarding those rights of proposed conservatees who have mental health, substance abuse, and other issues. Having said all of that, if there is a way where those rights can be protected with this so-called conservatorship light, and we don't have quite as much involvement of lawyers in the courts, I would be totally in favor of that. But more has to be seen about this, I think.
Right. I mean, LPS conservatorships are interesting. They're challenging. It's procedurally, they're very different from what we do in probate court.
Yeah.
But
by the way, I mentioned the right to trial by jury. Technically, a proposed conservatee in a regular conservatorship has a right to trial by jury.
Right. And occasionally
I have seen that right exercised only once, and it was by an attorney who was subsequently fired from the case. And I ended up litigating with somebody more competent over the issues of conservatorship. So, but it is there.
Right. Occasionally we hear about it.
Well, thank you, speakers. This has been very interesting and enlightening. Thank you so much, and especially Judge Johnson for the court's perspective, Bette for covering all of these basics and some alternatives, and Bruce for weathering the storm, even with COVID, and giving us all of those updates. Everybody, thank you once again for attending. As a reminder, we do have 2 further installments of this probate series. If you follow the link I just posted in the chat, you can register for those 2 events. In August, we'll have an event focused on fiduciaries and trustees. And then in November, we'll be looking at 850 petitions and 859 double damages, which should both be very interesting presentations. Once you sign off of the webinar today, you will be sent to a short survey. We would really appreciate if you take the time to fill out that survey and give us some feedback on the presentation today and some ideas.
Looks like Katie froze.
She did.
Yeah. I didn't.
Welcome to take a look at that once it's posted. Thank you once again to all of our speakers. We really appreciate your time today.
Our pleasure.
Thank you. All right, everybody.
Thank you
Have a
very
great
much.
afternoon, and thank you for attending.
And
Bye.
Bruce,
Thank you.
Thank you, Bruce. I hope you feel better soon.
Thanks.
Yeah, you were a
It's a
trooper.
pleasure working with you. Thank you, Bette.
You were a trooper to get through this.
Bye-bye.
Bye-bye.